Welcome, everybody. Thank you for joining us today. So today, obviously, we are looking to put on a procurement update for academies and academy trusts. I'm joined by my colleague Stephanie, and both of us are partners in the VWV commercial team with significant experience and exposure to the world of public procurement. So if we have a quick look at the next slide and what we're going to cover today. Firstly, I'll be taking a look at some recent and some relevant PPNs or public procurement policy notes, explaining the relevance of those and what they mean. And also then I'll have a look at some recent case law, which is relevant to what's going on in the world of procurement and updating the approach that we take to some of these things. And then I'll hand over to Stephanie for the big event, a review of the recently published Procurement Bill, finally upon us. And Stephanie's going to look at some of the changes that are going to be coming in as a result of that, or that we're expecting to come in as a result of that. And then, as Tamar said, finally, when we get to the end, hopefully there'll be some questions. Hopefully they won't be too tricky, and hopefully we'll be able to answer them. So just to kick things off, to start with, we thought we'd have a little poll to see how optimistic or pessimistic people are. The Procurement Bill has just recently been published, but when are we expecting it to come into force? There's no set date here, so it'd be interesting just to get a flavour of what people's thoughts are. And we've put down three simple choices: June 2023, October 2023, or sometime in 2024. So if you want to just quickly click and put your vote in for that, it'll be interesting to see where people think this is going to fall. Yeah, so we have 15% who are very optimistic and think it'll be with us inside 12 months. The general consensus is October 23, which I think is also the general consensus on a wider view. I think most people are probably thinking that October 2023 is likely. I, of course, am a pessimist. So with my experience of governments and legislation and the Lords and the Commons and people making cheap political points, I'd have gone for the 2024 comment, but that's, as I say, personal choice. So having a look now at some recent PPNs. So if we move on to the next slide, the first one to look at is PPN 122. And this is all as a result of, obviously, Russia and the invasion of Ukraine. This was published on 28th of March this year. It's the only PPN from 2022 so far. And we've had a lot of queries about how academies can respond to the Ukraine crisis. What are their rights? What, if any, are their obligations? We're delighted as a firm that we have a Ukrainian lawyer who has joined our commercial department. But when it comes to academy trusts, what can you do and what can't you do? And this PPN came out from the government as a way of of assisting with what can be done. As I said, published on 28th of March, it was intended to give guidance on rights and responsibilities. And the first point to note is that it's not binding on academy trusts. It's binding on central government and only central government. So academy trusts are encouraged to consider applying the approach set out. And what the approach is that it suggests reviewing any existing contracts and supply chains to see if any suppliers are based in Russia or Belarus or are controlled by a Russian or a Belarusian organization. And if the answer to that question is yes, then the guidance suggests considering terminating the contract if A, it provides rights to terminate, and B, just as importantly, if an alternative supplier can be sourced in line with value for money and minimal disruption to you. So that's in relation to existing procurements and existing contracts. And when it comes to new procurements, it's important to note that both Russia and Belarus are not members of the WTO and so can be excluded from taking part in future procurements if that is expressly provided for in the documentation. Quick note, you can't exclude organizations, Russian or Belarusian organizations, if they are based in the UK or have substantial business substantial business presence in the UK, as they would then fall within the scope of the procurement regulations. Now, the main area that I've had to look at for this is in relation to Academy Trusted Vendor contracts with Gazprom. And the main problem with those is that those contracts, the ones that I've seen, have been fairly watertight in terms of the termination rights. There are termination options, but they come with a very significant financial penalty. But that is essentially the position. And if you have any concerns about being in contract with Russian or Belarusian companies, this is the PPN that covers that. If we look at the next one, the next slide deals with PPN 921. And I've included this, as you'll see, mainly because I've had a number of questions from education sector clients and academy trusts as to its relevance. By itself, it's rather confusing. It needs to be read alongside the guidance note. Changes haven't been particularly clearly signposted. And what it deals with is the clarification on the use of contracts finder, and particularly publication of contract notices and contract award notices. And this has become more relevant because with the new procurement thresholds that have come into place in January, because they now include VAT, they've actually gone down in real time. But the obligations on Contracts Finder relate to opportunities and contracts that are worth more than £25,000. But the important thing to note, and this is very clear, is that academy trusts are exempt from the Contracts Finder obligations. So along with maintained schools, academy trusts do not have to publish notices on Contracts Finder. So that's one less thing to be an obligation onto you. So that's a helpful piece of information to bear in mind if someone brings up the concept of publishing on Contracts Finder. The next PPN I just wanted to touch on, and it's a slightly older one, if we move to the next slide, is PPN 521 and the National Procurement Policy Statement. This was the one that set up key outcomes the government believes contracting authorities should have regard to in commercial and procurement activity, and is picked up in the Procurement Bill. So again, this is just a reminder that it applies to all contracting authorities, so it does apply to academy trusts. However, the language is very much couched in a should and consider and consult type way. So it doesn't impose strict binding obligations, etc. Covers 3 national strategic priorities for procurement: social value, and contracting authorities should consider creating new business, new jobs and new skills, tackling climate change, reducing waste and improving supplier diversity, and make those their priorities in procurement activities. In terms of commercial and procurement delivery, you should be considering whether you have the right policies and processes in place to manage the key stages of commercial delivery. And when it comes to skills and capability, that you're considering your organizational capability and capacity, and ensuring that you have the appropriate skills and resources necessary to deliver value for money. And I think when we first saw this and moving still in place, it's really a question of looking at the guidance and realizing that what you're being asked to do is carry out an internal review to assess your procurement and contract management capability, and benchmark yourself against relevant commercial operating standards. So the key thing is to look, consider, are you set up appropriately in order to get best value out of your procurement activities, and critically, in the current context, are you aware of what is coming down the road? So that's it in terms of PPNs. 3 cases I thought it would be helpful to talk about at this point. And the first is the Good Law Project and the Minister for the Cabinet Office. Essentially, this is Michael Gove, our old friend, now in his position as Minister for the Cabinet Office, and his decision to award a £560,000 focus group contract to Public First Limited. And the reason this case caused more of a stink than a lot of others was on the basis that the contract was awarded to Public First. It was understood on the strong recommendation of Dominic Cummings, who back then was still in a job, chief advisor to Boris. And Mr. Cummings was friends with the owners and directors of Public First. And it was alleged that in awarding the contract, Mr. Gove did not consider whether, in fact, it could have been performed by any other research agency. The case was brought on 3 grounds. The first, that there was no basis for making a direct award under the regulations, as it wasn't strictly necessary. That awarding the contract for 6 months was disproportionate, and it should have been for a shorter term. And thirdly, most obviously, that the contract gave rise to apparent bias, contrary to general principles of public law and procurement. Actually, when it went to the High Court, the first 2 points of those were dismissed and found not to be the case. But the third point, the apparent rise, the rise of apparent bias, was upheld, and it was held that the government was in breach on that basis. This was, though, appealed to the Court of Appeal, which this time found in favour of the government and Mr. Gove, and found no apparent bias, but did criticise the failure to keep clear record of documents, and why it had made the decision to choose Public First over other agencies. So the point to take away from this, and it's something that we've talked about before, is the importance of keeping a paper trail. If you are making decisions, and you are making particularly decisions which you think may be contentious in the future, make sure that there is a process of documenting the decisions that you're making, noting that you have recognized the conflict or the potential conflict, the controversial nature of what you're doing, and why a decision has been made. Of course, these things don't always end nice and cleanly. The Good Law Project is currently looking to appeal the case to the Supreme Court, so who knows how long this one will run and run. But from our perspective, the key point to take away is that importance of documenting the process and the decisions that you make going through it. Looking at the next case, we have here a Danish case, the case of Simonsen and Wheel. At least I hope it's pronounced Wheel. It could, of course, be Veal, which would be more akin to VWV. So this was a Danish case. It was a supplier who was unsuccessful in becoming awarded onto a framework agreement panel. And they argued that the framework agreement and the setting up of the framework agreement was not valid and in breach of regulations because the tender documents didn't contain an estimate or state the maximum quantity that would be procured under the framework. And this was actually upheld by the ECJ, the European Court of Justice, which held that it was a requirement to indicate the estimated value of the supplies that would be called off under this framework agreement. And this is a particularly worrying decision for a lot of framework agreements, and a lot of academy trusts use framework agreements on a regular basis. And what this is saying is that if the framework agreement doesn't say what value of contracts can be called off from it, it is potentially in breach and not eligible to be in compliance with regulations. So as an academy trust, when you are looking to call off a contract from a framework, the first thing one of the things you should be doing is looking and asking the framework operator to confirm what the estimated and the maximum value of contracts that can be called off was set up when the framework agreement was set up, and then also what the value of contracts has been that has been called off. because if the framework agreement was set up on the basis that it could be used to allocate up to £5 million worth of call-off contracts, if £5 million worth of call-off contracts have been done, then that framework agreement is full, complete, and can't be used anymore. So it becomes now an obligation, a proactive obligation on you as procuring academy trusts to look into this, to check that this framework agreement is still viable and still able to be used by you when it comes to calling off contracts. Now, it is worth noting that as an ECJ judgment, it's not immediately binding, but it does seem to be sensible. It's one of those ones where when you see it, you think, yep, that's fully in compliance with the principles of procurement law, and it's surprising it hasn't been raised before. And then finally, just looking at the last case I want to talk about, this one's another one where I have problems with pronunciation. I think it's Adarad Recovery Limited and Anurin Bevan University Health Board. It was easier when we said Nye Bevan. So this one, Adarad Recovery, is a registered charity and tended to provide a mental health sanctuary service to their local health board, Anurin Bevan University, and was unsuccessful. And they sued for damages on the basis that the health board was in breach of its duties of transparency and equal treatment in how it carried out the procurement and how it awarded the contract. And of course, as everyone will remember, transparency and equal treatment are two of the fundamental general principles of EU law and procurement law. And Adarad Recovery felt that this was a strong basis for them to make a challenge. Now, a key point in this was that this was a below threshold contract. So below the thresholds at which full compliance with regulations are required, but it has long been the expectation that even for below threshold contracts, that the general EU principles would be followed. But crucially, and in a very important judgment, it was held that the general EU procurement principles no longer apply to sub-threshold procurements. And this is the case whether we're talking about light touch services, and just double checking, light touch services with a threshold of 663,540, or whether we're talking about goods and services at 213,477, both of which include VAT. If they are below those, and from a public procurement perspective, then there are no longer any public procurement requirements to follow. Please remember, of course, Academy's financial handbook, general charity principles, etc., etc. But from a public procurement perspective and a regulation perspective, below threshold contracts are now hands off and over to you. No need to consider the public procurement regulations. And then finally, just sort of wrapping that up with the next slide and some general themes of procurement litigation. The courts are looking more and more, and this is now ones that are above threshold, considering the contracting authority's approach to fairness, transparency, and non-discrimination. And the courts are now more and more interested in following that the contracting authorities, academy trusts, are following those principles. And if you don't, the courts will tend to act more strongly against you. There seems to be a greater use of judicial review. Judicial review, to my mind, has always been a very expensive and very uncertain process. If someone is successful in a judicial review challenge, it of course doesn't actually mean that they win anything. It just simply means that the process has to be run again. So although it is often threatened, and lawyers are particularly good at threatening use of judicial review on a regular basis, in previous years, it hasn't had that much use and that much exposure. We are seeing a little bit more use of it. And finally, without wishing to sort of remind everyone and poke what is what is certain to be hornet's nests. The recent issues that a lot of academy trusts have had with ESS SIMS contracts, there has been a significant rise in IT sector procurement challenges, and we are well aware of the action taken by Bromcom and United Learning, but essentially all of the problems that we had with ESS and looking to extend SIMS contracts from a 1-year rolling basis to a 3-year put a lot of academy trusts into a situation where they would be awarding an above threshold contract. Bromcom and other similar providers were very interested in this, looking for what contract would be entered into, and if they were in breach, then it would be a fairly straightforward challenge for them. So we're seeing more and more challenges in the area of the IT services, and that's something we will, of course, be keeping an eye on. But now over to the main thrust of the interest here. I think I'll hand over to Stephanie to look at the new Procurement Bill. Stephanie.
Thanks very much, Matthew. Good morning, everybody. It's been, I can't believe that it's been 18 months, more or less, that we've been talking about the transforming public procurement reforms, and we finally got the Procurement Bill. So the purpose of today is to give you a taster of what to expect and to discuss some of the main changes you are likely to see. Of course, the bill is making its way through Parliament. It started off in the House of Lords. So there will be a number of changes that will be made, and I'll talk later on about the anticipated timetable. Now, the government's stated aims in the Procurement Bill are to introduce greater flexibility following the UK departure from the EU, to provide greater access for SMEs and to simplify the procurement rules. What they have done in the Procurement Bill is that they've taken the public contracts regs, the utilities regs and the concession regs, and they've consolidated the regulations into one procurement bill. So for those of you that have got catering contracts under concession types arrangements, they now all fall within the Procurement Bill. Now, I'm pleased to say that if you look at the Procurement Bill, it is actually shorter than the current public contracts regulations. So that's one good thing. Also means that actually you've got, there's a lot less substance in there than you had with all of the rules. And that might create a problem. We're going to come and talk about that later. One of the benefits when you read the Procurement Bill is that it's much easier, I think, to read and clearer. You'll notice that there is a significant change in terminology. Now, that's partly political, to get away from the old EU speak, but it is also to make things clearer. However, that does come with some complications. For those of you who've been practicing procurement for a while and are familiar with the old terminologies, we've now got to learn a completely new set of terminologies, and some of them are slightly confusing. So the contract notice, which is traditionally the start of a procurement procedure, is now going to be replaced with an appropriate tender notice. The old underpinning principles of fairness, transparency and non-discrimination have been replaced by new principles and objectives under the bill. Now, the objectives under the Procurement Bill are value that academies and all other public contracting authorities have to have regard to, a value for money. It's always been implicit, but not actually stated. Acting for the public benefit, acting and being seen to act with integrity. And then there is one about sharing information. We've got principles of fairness and non-discrimination. The principle of transparency is not explicitly stated as a principle under the Procurement Bill, but does weave throughout all of the Procurement Bill's sections and does come up from time to time. Now, I've talked about the application to the devolved regions because it's important to note that the Procurement Bill will apply in England and Wales. Wales have got the right to introduce some changes which are particular to them. So, for example, they are in the process of introducing a new Welsh strategy which will underpin their procurement requirements. Scotland have taken the decision that they don't want to be party to the Procurement Bill, and in fact they are going to rely upon the previous version of, or their equivalent version of the Public Contracts Regulations. So there is a big change in the competitive tendering procurement routes. Currently, there are about 5 procurement routes that you can choose to go down to. Now, that is being simplified to 2 procurement routes. The first is the open procedure, the one-phase open procedure. The alternative is the sort of design it yourself procurement process, whereby you can decide how you want to build your procurement process, which will give you greater flexibility. And one of the areas where I think there'll be a big improvement is in relation to IT procurement, where the procurement rules have been difficult to apply. So there's greater flexibility to introduce demonstrations or trials, for example, and you might want to introduce phasing into your procurement procedures. So on the next slide, I've set out some of the key changes. I think probably the biggest area, apart from the flexibility of the routes, is in relation to selection and award. So most of you will be familiar in relation to the most economically advantageous tender terminology to decide who is going to be the successful bidder. That is now being changed to the most advantageous tender. Now, interestingly, the general commentary is that in practice, there may not be much difference in its form over substance, but I think perhaps it's a reminder to academies and other contracting authorities about the ability to use social value and environmental considerations as part of that award criteria. There are important changes to the exclusionary framework. So academies and contracting authorities have a right to exclude a bidder if they are unsuitable to bid for a public contract. Now, in practice, it's been quite difficult to exclude a bidder under the exclusionary framework. And the framework is going to be considerably expanded. One of the areas that's often quoted by the government, and indeed was part of the consultation, was in relation to poor performance, where you can only exclude somebody for poor performance if the poor performance has actually resulted in the contract being terminated. Now, there will be new rules to say that if there have been discussions about poor performance under the contract and remedial provisions have been agreed, but they haven't been complied with, then there will be the right to exclude a bidder. There are also there's a change from the discretionary right to exclude to a mandatory right to exclude for serious competition infringement. The right to exclude also goes down the chain, so it's not only if the supplier has been caught out by some of the mandatory exclusionary grounds, it's also if a connected party, for example, a parent company or a subsidiary or subcontractors, have been found to be in breach. The government are going to introduce a debarment register, which will make it easier for academies to check whether some of the suppliers are guilty of or have been found to have infringed some of the mandatory exclusionary grounds, so that it's a bit easier to apply. I'm going to talk now about some of the remedies I'm going to come back to, but the standstill provisions, there's been quite a change from the original proposals. So originally the proposals was that the standstill letter, which you send to unsuccessful bidders after you've decided that you're going to award a contract, would be got rid of completely. Now, the government of Cabinet Office have rethought this, and the compromise position is that academies will still have to publish an award notice, which will publish the outcome of the procurement and the identity of all of the bidders. But unsuccessful bidders are going to get a lot more information. Instead of having the standstill letter, which sets out the scores of bidders and the characteristic advantages of the winning bidder, unsuccessful bidders will be provided with redacted evaluation documents for the winning bidder and their own individual evaluation document. So there's going to be a lot greater emphasis for evaluators on making sure that when they're writing their evaluation reasoning, that it's clear and comprehensive, because that information will be available to unsuccessful suppliers. There is a theme that goes throughout the bill that, although transparency is not actually mentioned as a principle up front in the procurement bill, there is a great more focus on transparency. So you'll find that there's a lot more notices that need to be published throughout a procurement process. There's also a change to the standstill period. I think it's a change for the better. At the moment, we have this rather singular method of calculation of the standstill period of 10 days. And then if your standstill period ends on a weekend or bank holiday, you flip to midnight on the following working day. There's going to be a change so that the standstill provision is calculated in terms of working days. But there are a number of tweaks to the standstill provisions that academies will need to get used to, or suppliers will get used to, because it's going to make it much more difficult to bring a challenge and preserve some of the remedies if you don't bring a challenge within the standstill period. Cabinet Office are going to have a new procurement oversight. So at the moment, we have the procurement policy review mechanism, which took over mystery shopper, but Cabinet are going to have much greater powers to demand documents and to ask questions of contracting authorities to make sure that there is compliance with the rules. Now, one of the areas that have been introduced, new areas that have been introduced in the procurement bill, are new contract management provisions. So these are aimed at implying prompt payment provisions. They are aimed at ensuring payment within minimum timescales, and that applies both for supplier all the way down the supply chain, also to the contracting authorities, and their provisions about contract performance. Now, you'll be pleased to know that academies are going to be exempt from much of these. But one of the big changes that academies will not be exempt from is the requirement to publish contracts above 2 million. Now, one of the issues that I have talked about in previous webinars is about resourcing and privacy concerns around the proposed transparency requirements. There was going to be a much lower threshold for publication of contracts. But after quite extensive lobbying from the education sector, the Cabinet Office has agreed that the increased transparency requirements will only apply to contracts in excess of 2 million. So probably not so much of an issue for smaller or single academies and trusts, but may well be an issue for the larger multi-academy trusts. Matthew talked about framework agreements, or the case about frameworks in his session. There are going to be a number of changes to the framework rules, and this will be important for academies. So it will be possible to have a longer framework period through a mechanism called open frameworks, where people can reapply for their place. And the dynamic purchasing system of procurement, which is effectively electronic framework agreement for goods and services, is going to be extended. Now, what was interesting is I went to a talk yesterday about the current provisions in the Procurement Bill about frameworks, and they are very, very light touch. There's not very much detail in them about how actually the framework process is going to work. And so one of the things that is going to be happening is that the government have said, here is the procurement bill, but because we managed to squish it into so many pages, we're going to have to issue a lot more guidance to supplement the bill. Now, that isn't available yet. It's not clear entirely when it will be available, but there will be quite a lot of additional information, for example, guidance on the framework agreements. But I think it is going to, there will be pros and cons. It might be harder to make sure that you're able to get the benefit of a framework, but you will have more flexibility, I think, in relation to how contracts are called off under framework agreements. So then, moving to the next slide, in particular issues for the education sector. I've talked about the fact that there is going to be more guidance. So there's going to be, for example, there's going to be guidance on what needs to be included in all of these notices that are going to be required under the Procurement Bill. One of the things that has also been changed in the consultation process is the light touch regime. Originally, the government said that they wanted to do away with the light touch regime, which, as you'll be aware, covers a lot of education contracts. Now, they've decided, following responses, that they're going to keep the light touch regime, but they haven't given much details about the process. But that, again, is going to come through guidance. So we don't know, for example, what services are going to be caught and what the process is going to be. I think there will be the ability there'll be a change in timescales, for example. There will be, I think, an increase in resourcing requirements. And I'm speaking to academic clients. I'm very acutely aware that it's very difficult to get our procurement resource at the moment, and it is very limited. Necessarily, there's going to be time needed to get up to speed with the new regulation, with the new bill, because they are quite different. And also to make sure that all of these notices are published in the appropriate timescales. There will be training provided by Cabinet Office as part of the implementation period. Now, I've put a bullet point there about the implications for FOIA. So many of you will be aware about FOIA and have to deal with FOIA requests in relation to schools and students. Now, one of the aspects that I think is going to be an issue for further discussion is the extent to which academies are going to be able to rely upon FOIA to exclude from publication some of the commercially sensitive information about their contracts, and that's something that I'm discussing with my colleagues within VWV. So just an update then on the process for the Procurement Bill to come into force on the next slide, please. So, as I say, the Procurement Bill is progressing in the House of Lords. Now, it has reached the committee stage, but my understanding is that the committee stage is going to go to committee stage, but that isn't going to be completed till after the summer recess. So that's going to take us through till the autumn. And I've just picked up something on the chat. So FOIA, apologies, should have referred to the Freedom of Information Act there. So the House of Lords, it goes through committee stage, and then there's another, I think there's a third reading before it goes to the House of Commons, and then it goes through the House of Commons stage before it reaches was finalised and is given royal assent. Now, Cabinet Office have been very clear and said that there will be a 6-month go-live transition for the guidance to be published and for all the training to be undertaken. So my guess, I think that it is going to be the end of 2023 before it comes into force. So I have had some clients who are saying, well, should we wait for the new procurement bill to come into force so that we can take advantage of all these changes? But I think it's going to be quite a long wait, and obviously there are some procurements that can't wait that long. We've talked about supplemental guidance, and I think we've talked about training, learning, and development. So just in terms of points to take away, in terms of, on the next slide, what does this mean for academies? I think you'll find that a lot of the increased flexibility will be welcomed, and you'll have much greater discretion to be able to carry out processes as best befits the type of procurement that you're working on. I understand that Cabinet Office are intending to publish some model procurement processes. If you don't want to design your own, you will be able to use their model processes. As Matthew has said, for below threshold procurements, you're going to have a much greater flexibility because the old EU rules won't apply. You do benefit from some of the exemptions from contract management, so that's a good big sigh of relief, I think, from your point of view. But expect greater transparency, not only in the notices, but also in the way that you do things. I haven't talked about changes to contracts. So for those of you who've got long-term contracts, carrying out amendments and changes will be part of that process. And there is a very detailed suite of rules on the extent to which you can make modifications to the to contracts which have been procured. and that's going to be subject to a lot more scrutiny. So I always say this in all of my webinars, but the importance of keeping a detailed audit trail will still be there and will be greater, because I think you're going to need to be able to set out your thinking and your justification for each stage of the process. Finally, we are still getting to grips with the Procurement Bill. It will be changing over, we're getting to grips with the Procurement Bill. It will be changing as it goes through the parliamentary process, and we're just planning our training for the next 6 months to a year for academies and for our other clients. And we'd be really grateful if you've got any thoughts or feedback on what would work well for you, whether it's sort of mini webinars in sort of 10-minute slots on a particular area, or whether you like sort of half-day training, or whether you like sort of written articles. If you're able to feedback, that would be great. So next slide, I think, is any questions?
I don't think we have any open questions, Stephanie. I think we had a FOIA question, and that's it. So if anyone has any last-minute questions they want to put down, we've either done such a good job of explaining it, our attendees are either excellent at it, or we've put most of them to sleep. Here we go. Right, there is an ability under some frameworks to direct award. Will this be covered in the new legislation?
The answer is yes, it is going to be covered in the new legislation. So if you clearly, if it's a single supplier contract, you will direct award. There is a. I mention this because there is some discussion about whether you have to direct award on the same terms, where there's a bit of flexibility about an ability to negotiate a particular call-off contract. The issue about direct awarding and circumstances for direct award under multi-supplier frameworks is not yet there. This is an area that's going to be covered by guidance. So I hope that helps, Julia. Right, so the answer is yes, it will be capable of challenge. Under the existing rules, if you don't follow the procedure properly, then actually it's one of the grounds for ineffectiveness. Now, I'm just trying to, I'm just trying to remember the rules. I think it is still the case that you don't have to comply with a standstill period if you're calling off a contract, but you can do that if you want to. And what is going to be interesting about the point of challenge, that if it is correct that there is a greater flexibility as to how you call off contracts, then it may be more difficult to challenge, which is probably good news for you. But we're going to have to see what the guidance says. And one of the issues is that we have got this, because the Procurement Bill has been consolidated, there are a lot of unanswered questions. And I think frameworks are a particular area where I think procurement lawyers are asking for a bit more certainty.
I think I just chip in on that. One of the larger areas that I've been working on over the last year or two is on calling off of framework agreements and not following the formal processes set out in those framework agreements, all the way through to the point of suppliers saying, yes, I'm on a framework and you can just call me off directly. And by the way, here are my standard terms and conditions which are going to apply to the relationship. Of course, those are not the terms and conditions set out in the framework agreement, and therefore that is an entirely non-compliant contract. Simply because a contractor or a supplier is on a framework agreement doesn't mean that that awarding them a contract is covered by the protection given by the framework agreement. So it is very important to follow the processes set out in the framework agreement, A, for the award, but critically also for the form of the contract itself. And don't be tricked into saying, well, everyone else agreed to make this change, so why can't you? Not a good legal argument, that one.
I think in practice that framework agreements are going to be very heavily relied on, particularly in the first sort of few months of the procurement bill, because everybody's going to be worried about challenges and trying out things. And so framework, of course, my understanding is existing framework agreements, providing they're still in force by next year, will carry on and you'll still be able to call off under them. So I think, that people will be wanting to use framework agreements for that sort of security. But as Matthew said, it's only security if you follow the rules.
So a question about the thresholds below which not all the regulations apply in full. So I can confirm that, and I've brought them with me, so I've got them absolutely correct. So they were updated on the 1st of January, and for contracts for the supply of goods and services, the threshold is £213,477. Pounds. For capital works, the threshold is £5,336,937. And for light touch services, the figure is 663,540. But the critical difference now, as from prior to 1st of January, is that those figures are inclusive of VAT. So you have to add VAT if it's chargeable to the contract value to work out whether it's below threshold value. So unless there are any more, I think that's a good point to wrap it up. I think just under the hour. I shall let Tamar do the sensible stuff at the end. So thank you very much for staying with us. If you could give us your feedback on the poll that's just come up, that would be most appreciated.